How do you win a chronic pain case if there's no objective evidence setting forth the reasons that you are in pain? I'm Jonathan Ginsberg. I'm a Social Security disability attorney. I represent clients in all 50 states, literally from Maine to California. I'm able to do that because disability hearings are now held virtually by phone or by video. So where you live, where I live, does not make a difference. It's all done by phone or video. And I want to talk to you today about pain cases because I see a lot of clients, people contact me and they have chronic pain. Sometimes there's a cause, sometimes there's not a cause. Sometimes the pain seems in excess of what the underlying objective evidence might show. Now, the CDC estimates that 20% of the United States population has chronic pain, and this is a level of pain that would be significant enough to curtail activities of daily living. When people are, for people over 40, it's close to 40%. It ranges, and again, but there's arguments and there's statistics to say that around 40% of the population of people over 40 experience at some time or another chronic pain to the point where they cannot function reliably at a job or with activities of daily living. Obviously, in some of those cases, the pain is temporary, but sometimes the pain is more permanent. Those are the folks that might consider applying for Social Security disability. Now, realize why Social Security judges in particular will turn down pain cases. One is if there's really no objective evidence at all. And this is where we get into things like fibromyalgia or some sort of chronic myalgia, chronic pain syndrome. And if there's really no cause for it, it really boils down to whether the judge believes you or not. And sometimes judges will believe you, but generally speaking, they're looking for some sort of a cause. Now, the Social Security does recognize, for example, that fibromyalgia does exist, but they're looking for clear evidence backing up that you actually have it. I'll get to that in a second. The second reason judges turn down pain cases would be if the level of pain you're describing is out of sync, as it were, to what the objective evidence shows. For example, if you have a bulging disc at L5-S1, which is fairly common, but you're claiming pain that is debilitating. You cannot focus. It is running down your leg. It is severe to the point where you literally cannot do anything at all. You're in a recliner all day long. Many judges would say, well, the level of pain you're describing is not consistent with a mild bulging disc. Now, if you have a herniated disc with nerve root impingement, maybe that level of pain is consistent, but a bulging disc, a lot of people, in their 40s and 50s and 60s have bulging discs, and they may have some discomfort, but not the level of pain that would be debilitating and would preclude work. So what do judges look for when they're dealing with a chronic pain case where there is no objective evidence or the objective evidence is not really consistent with the level of pain being described? First of all, they're going to look for ongoing regular medical treatment. I'm talking about treatment over a period of years where you're treating with, whether it's a surgeon who's decided you're non-surgical, a pain management doctor, somebody who is going to treat you and basically recognize that, yes, you are sincere about your pain and that there's really no surgical resolution to it, but that pain management would be the only thing, whether it's pain medications or whether it's injections or some sort of other therapy. A few ER visits and a general practitioner visit is not going to be enough. It's going to have to be with a pain management specialist, a physiatrist, somebody who deals with chronic pain and who believes that you are not drug seeking or have secondary gain. So that's one thing judges are going to look for. They're going to also expect that you're going to be fully cooperative with any medication trials that the doctor has provided. So in other words, many people, when they have chronic pain, the doctor will start them off with one type of pain medication. Maybe they get Neurontin for nerve pain. Maybe they have hydrocodone. And they may keep switching those pain medications around. They may have a patch, oxycodone. There's any number of different medications they could try, but the judges are going to expect that you've tried those medications, you've been consistent with them, you've not overdosing on them, you're not taking too much, you're not claiming your prescription ran out early, you're not going, and this is a real red flag, you're not going to multiple doctors asking for the same medication, things like that. So they're going to look for situations where you're following your doctor's advice and you're getting pain medication as it is prescribed and you're being fully compliant with it. Judges will expect that you will pursue non-invasive procedures, things like epidurals, radiofrequency ablations, facet blocks. These are things that are not necessarily comfortable. I mean, it can, getting an epidural can be a little bit uncomfortable. A radiofrequency ablation can be uncomfortable, but it's not surgery. And so if you have chronic pain, judges expect that you're going to do everything you possibly can to deal with that. Physical therapy, ice, swimming, things like that. But they're going to look for epidurals, again, facet blocks, that sort of thing, to show that you are really trying to deal with this pain and that you are sincere, that you are trying to get past it so you can either go back to work or resume your daily activities. I think it's also helpful to have support from a treating doctor, and basically this would be in the form of a narrative report or a functional capacity evaluation where the doctor says that you have been going to that same doctor or doctors like that person for 2 or 3 years. You've tried everything they've given you. You've tried medications. You've tried TENS unit. You've tried spinal cord stimulator. You've tried epidurals, facet blocks, all those type of things, and nothing has really helped. And yes, and because of that, the doctor feels that you are not able to work. And you're not really asking for the doctor to say you're disabled. You're basically want the doctor to say that your capacity to perform various functions that are necessary for work do not exist. So even with all these factors, it can still be a challenge, because there are judges out there, I'm going to tell you, who believe if it's not on an MRI or a CT, it doesn't exist. They're going to take that anybody who says I'm in terrible pain, they're going to assume a mild level of pain. So you can get past that sometimes, and I've actually had a couple of appeals counsel and district court remands from judges who would not accept a claimant's testimony of chronic pain despite all the factors that I've talked about. So Social Security does recognize that chronic pain is a condition, but you're going to have to go the extra mile. You're going to really have to have a very detailed and very supportive medical record if you hope to win one of these type of cases. Please visit me online at ssdanswers.com. You can ask for a free case evaluation. You can sign up for my download, which is it's actually delivered by email, Secrets to Winning Disability Survival Kit. If you'd like to leave me a question or leave me a comment on this video, give it a thumbs up if you think if it was helpful to you. Subscribe to my channel, click the bell so you get notices when new videos are coming out. And again, if I can help you in any way, happy to try to do so. Again, my name is Jonathan Ginsberg, disability attorney, and I look forward to hearing from you soon. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.